Any mention?
May I please, Your Lordship?
Yes.
I beg to mention item number 12, Lordship.
Yes.
Due to personal difficulties, Lordship. After 1 week, Lordship.
After?
After 1 week, Lordship.
It will be after 2 weeks, Your Lordship.
And your blessed, Lordship.
After 2 weeks at the request of the petitioner.
Apply.
May it please, Your Lordship,
Yes.
I beg to mention item number 13, Your Lordship.
Yes.
The conducting counsel is indisposed, Your Lordship. The matter may kindly taken up after 3 weeks, Your Lordship. Yes.
No objection, Lordship.
This also at the request of the petitioner. Just after 3 weeks. Yes.
Oblige, Your Lordship.
May it please, Your Lordship. Lordship, I beg to make a mention of item number 9, Your Lordship. Lordship, I pray if this matter may be taken up after 2 weeks, Your Lordship, as the learned DSGI is indisposed, Your Lordship. No objection, Lordship.
This also at the request made on behalf of Mr. Dr. Majika. London GSJ. Just after 2 weeks.
Much obliged, Lordship. Yes, Your Lordship, I beg to mention item number 2. Your Lordship, the counsel Mr. SD is on sanction leave. Let it come after 2 weeks.
Be louder.
Is on sanction. Mr. SD is on sanction leave, Your Lordship. Kindly take up the matter after 2 weeks.
Yes, he's on leave.
Just say request has been made on behalf of the. Your respondent number?
123, Your Lordship. For district council.
Made on behalf of the respondent number. Fine, sir. To adjourn the matter. Mr. Ajarika, London counsel for the petitioner has no objection. Prayer allowed. List of 2 weeks. Yes.
Must.
Your Lordship, a similar prayer for item number 3 also, Your Lordship.
I don't know where.
Number 3.
And for the private response is not foreign fact matter.
And for the petitioner, Your Lordship.
None of you have objection. Okay. There your respondent number?
Now, same, Your Lordship. 1 to 3.
Same.
Yes, Your Lordship.
Same order, just change the name of the council. Yes.
Hello,
Your Lordship, I beg to mention item number 6, 7, and 8, Your Lordship. I pray that the matter may be taken up after 2 weeks, Your Lordship.
No objection, Lordship.
Sir, all what? These are quashing matters?
Yes, Your Lordship.
Okay, after 2 weeks.
Yes, Your Lordship. 6, 7, and 8,
At the
similar.
request of the petitioner, list after 2 weeks. Yes.
And your oblige.
May I please, Your Lordship, I'd like to beg to mention item number 11.
Yes.
Your Lordship, the conducting counsel is out of station.
You are appearing for?
HR not, Your Lordship. On behalf of HR not.
Who is the other side? No one for the state here. Item 11.
No objection, Your Lordship.
When do you want it?
After 2 weeks, Your Lordship.
It's also at the request of the petitioner after 2 weeks. Yes.
Much obliged.
Daily costless. Item number 1.
Yes.
Yes, Your Lordship. Lordship, on behalf of respondent number 5, I pray for 1 week time to file my affidavit.
And what about others?
I have similar prayer for 6 and 7. 2 weeks time.
2, 3, 4, we are not filing, Your Lordship.
And number 1 is the state. Okay. Yes, sir.
Lordship, there's an interim order, Lordship, 19/6/2000.
Yes, let us see. Let us first what is that? Just say. Any application filed again interim this thing, interim prayer. Any objection has been filed?
No.
Nothing has been filed. Okay. Mr. So-and-so on GA appearing for the respondent number 1 and Mr. BGK Quintal on senior advocate appearing for the respondent number 2, 3, and 4.
2, 3, 4.
Yes. submit that no affidavit in opposition is required to be filed on behalf of the side respondent in this matter. However, Mr. I don't know, Mr. So and so appearing for the restaurant number 5 and restaurant number 6 and 7. However, Mr. So and so appearing for the restaurant number 5 and Mr. So and so appearing for the restaurant number 6 and 7. Okay, pray for grant for some time to file their affidavit opposition in the matter. Then you say prayer allowed. How long you'll be taking?
3 weeks time, Lordship.
List this matter after 3 weeks.
Look, Lordship, can this matter be listed along with WPC 149, Your Lordship? It's connected matter.
Yesterday another matter was before your Lordship.
We have challenged.
Okay. So that matter is coming up when? After 3 weeks only?
3 weeks. Yes.
Let that matter come up first.
2
Then
weeks.
that
At least
can
Lordship
bring
will
this-
file after
So right now it is not required to be tagged together, Mr. Kinta.
Lordship, better.
No, let the other matter come out first because it come first, the other matter.
In the meantime,
Within,
we
within a
granted
week's
2 weeks
time.
time to file our affidavit, my lord.
No, Lordship, let them tag together, Lordship, because of that order
When this other matter is coming up?
on 26 July, Lordship. It was listed yesterday. Yesterday, it granted Your Lordship was granted 3 weeks. Then the next date will be on 26 July.
Okay, then we can have it on the same day, Mr. Kinta.
Yes. I think it's okay, Your Lordship.
What is then list after 3 weeks? Then you say on the request of the respective parties, let this matter be listed together with. Give the other petition number.
WPC 149, Your Lordship,
Yes.
of 2024.
Then subpara. Yes, if you make this interim order absolute, then what happens? You're not having any objection? Not fine.
We'll file our affidavit.
2 weeks.
So what about making it absolute till the disposal of the writ petition?
Lordship will have to hear us.
Look at us. Why are you looking that side?
Lordship will have to file our affidavit.
Okay,
will
okay.
reply
The
first.
interim order passed earlier. In the meanwhile, just to say, in the meanwhile, the interim order passed earlier shall continue till the return verdict. Yes.
Obliged, Your Lordship.
Privilege.
Lordship, right. Good day.
Hearing item number 4.
Yes.
Please, Lordship. Should I file my objection? I'm appearing for the private respondent number 2.
You filed it.
Yes, Lordship.
So, when do you want this matter to be taken up for hearing?
2 weeks, Lordship.
No objection, Your Honor.
Mr. Kharkang, Learned Counsel appearing for the respondent number 2 submits that an objection in this matter has already been filed. Come on, you have received a copy of the objection?
Yes, Honor.
Yes, Mr. Swainson, Learned Counsel appearing for the petitioner acknowledges receipt of copy of the objection. Come on. Then you full stop in view as prayed for by the Learned Counsel for the parties. List this matter after
2 weeks, Lordship. 2 weeks.
2 weeks. 2 weeks.
Lordship.
This is already the hearing column, isn't it?
Yes,
Is it in the
Lordship.
hearing column?
Yes, Lordship.
So it will come up for hearing. Nobody is appearing for the respondent number 1.
Respondent 1, state, Lordship. State.
Respondent 1 is state.
Yes, Lordship.
Oh, on the last occasion also nobody appeared. Today also none. Mr. Sulai, what is happening here? We do not file. On the last occasion also no one represented the state.
I'll see into the matter, Your
At least please see somebody should be there.
Item 4, yes. I'll see into it.
Lordship.
Apply, Your Lord.
Item number 5.
Yes.
May it please your lordship. May it please your lordship. In this case, we have filed an applications under section 482
For
of CRPC for questioning of the GR case 9 of 2021, your lordship.
under section
419, your lordship. Which has been arose out of FIR dated 6/3/2020, your lordship.
and what is the ground for quashing?
Grounds of quashing that the case in disputes is totally of civil nature, where they have filed a FIR, try to give a clock of criminal cases, your lordship.
Okay.
Now, your lordships can kindly come to the FIR.
There is a private respondent in this matter.
Respondent number 2. Your lordship.
You are appearing for the private.
Lordship, the conducting counsel, Mr. J. Shilai, is on next.
So what is to be done? What is your prayer then?
Lordship, a week's time will be given.
Lordship, with the observations that no further adjournment will be granted in
No,
this
you
case.
see, otherwise you can do one thing. You can carry on. Let us see if it doesn't come to this court doesn't want to. You see, like hear the matter on peace. That is the main thing.
Yes, your
If we hear it, then we will finish. So that is what you see. It should not be something like that. That is for the convenience of the council also.
Yes, your lordship. So, from my side, I am ready to argue. My learned
Then
friends,
it's okay. Then it's okay. Then you carry on. You just see. You carry on.
your
We'll
lordship.
require them if you can make out a case, then only we'll.
Yeah,
carry
yes,
on.
your lordship.
Yes.
Oblige, your lordship. Now, if your lordships can kindly come to page 41, your lordship.
Page 41.
41, your lordship. Annex. Sorry, your lordships. This is so your lordships page 30, annexure 6, your lordship.
Yes.
If you may allow to read the FIR, your lordship.
Yes.
With reference to the subject cited above, I, the undersigned, I am to inform you that one person named Sri Sweet Bikonia, so-and-so, resident of so-and-so, claimed herself as a distributor of AC organic bag. Now, AC is the abbreviation used for the company, your lordship. Company name is Sandur Enviro Private Limited.
Okay.
Your lordship. And the persons offer me to be as a supplier of this plastic
You read it. Okay.
plastic
Yes.
within Joy areas, and I have to give rupees 5,25,000 for 1,000 kg AC organic bag. Hence, on the 12/10/2019, an agreement have been made in written, to which Srimati Sweet Bikonia Eltron promised to get me 1,000 AC organic bags, 1,000 kg of AC organic bag at the rate of rupees 5,25,000. At the same time, I gave her a check having number so and so, paying rupees so and so. But after a few days, Srimati Sweet Bikonia Eltron informed to me that she cannot withdraw cash from the mentioned check. So on 22/10/2019, I have transferred an amount of rupees so and so from my account so and so Meghalaya Rural Bank Joy branch to the account of Srimati Sweet Bikonia Tron, bearing account number so and so, ICICI Bank, Shillong. Later, after I had paid the said amount, Srimati Sweet Bikonia Tron did not give me 1,000 kg AC organic bag. Several calls I have made a contact with her to remind her, but she gave excuses that she was outside the state. On the 10th January 2020, I have met director of Sandur Enviro company who supply AC organic bag located at Moprem, and he told me that Srimati Sweet Begonia Tron was not the supplier of AC organic plastic bags of the company. Therefore, I have lodged a complaint to the company for helping me so that I could get my money back. Moreover, regarding this matter, I have told to Sri Aganstar Kurklang of Madan Rating Shillong, and later he informed me that Sweet Begonia Tron will pay the amount of rupees 5,25,000 by paying rupees 50,000 per month. We have decided to meet Srimati Sweet Begonia Tron on 4/3/2020 at July to solve the matter. However, on 4/3/2020, Sweet Begonia Tron came along with Srimati Josephine Sada, president of so-and-so, and others, and made me a compound of the office of the Deputy Commissioner Joy, and told me that she cannot pay the money amounting to rupees so-and-so. This shows that the person Sweet Begonia cheated me, of which she was unable to repay my money back, and also she cheated that she was the distributor of the company who supply AC organic bag. Hence, I requested Your Honor to take necessary actions against so-and-so. Now, as per this FIR, Your Lordship, there is two allegations. First, I have personated to be a distributor of the company, which they allege that I am not. And the second, I have cheated the respondent number 2 by not supply the AC organic bag. Now, after lodging the FIR, the state machinery set into motions and filed the charge sheet. Charge sheet for under 419, Your Lordship, that the section has been incorporated, 419 against me. Now, before coming to the charge sheet, I would like to take Your Lordships, allow me to kindly brief the court about the facts of the case, Your Lordship.
We may not go to the facts. Why? What for you should go to the facts?
Because
so long,
Your Lordship,
there is prima facie criminal allegation against you, that is good enough. We will not go into the merits. No question.
Your Lordships,
Two things is certain,
Your Lordship,
as you also say, that the allegation of impersonation,
yes, Your Lordship,
and cheating,
yes, Your Lordship.
good enough. Is the trial?
Your Lordships, that if on the record, if I be able to satisfy Your Lordships that no criminal offence can be constituted against the petitioner herein, then
you would like this court to go to the merits of the case.
On my humble prayer is that Your Lordships kindly on the record. I'm not going beyond any record, Your Lordship.
See, the proposition of law as laid down in Bhajan Lal's case,
Your Lordship,
which has been followed till date, that is the leading case.
Yes, Your Lordship.
It says the interference is only possible if the acceptance of the allegation made in the FIR doesn't make out a case, cognizable case. So that is good enough. And so far as the allegation here is concerned, it makes out a case.
Your Lordships, Your Lordships kindly rightly pointed out State of Haryana versus Bhajan, paragraph 102. The Supreme Court has laid down 8 conditions.
7 conditions, perhaps 7 or 8.
It's 7, Your Lordships. My apology, Your Lordship. Now, if my case falls under the guidelines number 1, Your Lordship.
What does it say?
Where the allegations made in the first information reports or the complainant, even if they are taken at their face value and accepted in their entirety, do not prima facie constitute any offence or make out a case against the accused.
So that is, it is to be taken at face value. So you are taking, you have yourself have raised out just,
Your Lordship,
and you said the allegation. What is the allegation? It's impersonation and cheating. So that is coming from your person only. That is good enough.
But it has to.
We do not have to go any beyond. We do not have to proceed any further. That is good enough.
Your Lordship, even in this same judgment,
this merit of this allegation.
Yeah.
Now you may say that these allegations have been made without any factual basis. We will not go into those things. Whether it has a factual basis or not, that you prove it in trial. This FIR is good enough. It makes out a prima facie case against you, if it is accepted. And if you say that if the acceptance of this fact is correct, then it will result in conviction. If you accept this fact, obviously there is no question you will accept it.
Your Lordship.
Okay. But then at this stage, at 482 stage, we move by assuming that whatever is stated in the FIR, that is correct. Because you are seeking quashing, isn't it?
Your Lordship.
So
I'm
we are
seeking
not
quashing.
going into the other aspect, the merits of the allegation. Allegation is there, it requires to be investigated. That is matter is simple. There is no complication here.
Your Lordships, this is totally a civil disputes because here it's the breach of contract. Though there are allegations, I have breached the contract. Now, breach of contract, there is another alternative remedies as available to them. Just by lodging an FIR, and try to give a criminal cloak to the civil disputes.
You know, Mr. Roy,
Your Lordship.
you must be well aware of law. Just because an FIR
Your Lordship.
has certain civil elements involved in it, does not make out an entire case of civil. Once certain aspect of criminality is involved, that is good enough. So, basing on these facts, the law allows maintenance of both civil proceedings as well as criminal proceedings.
Your Lordship.
Now, had there been no allegation of impersonation, had there been no allegation of cheating, maybe you could have termed it as civil dispute. Saying that, see, I have one agreement executed for supply. Now, if I fail to do it and all, the remedy would be under civil law. They can go for recovery basing on the agreement or maybe specific performance of contract. But then here it is not that. Here it is a totally case where allegation is that he impersonated as an agent of certain company which you are not. And you have taken money and you have not supplied. That is good enough.
But the agreement is executed, is there, Your Lordships, in the record between the company as a distributor and with the private respondent too, Your Lordship. Now, Your Lordships, kindly bear with me. On the record, I will show that there is an agreement executed by the company and
No, you see,
and the petitioner.
we have to first see the validity of the agreement.
Your Lordship.
Who have actually executed it or not. This court cannot. You see, the company is not here before us as a party.
No, Your Lordship.
Then we cannot this thing. And even if it is a party also, as this court has already said, we are not going into the question of the very correctness of the allegation. No way this court is judging.
Your Lordship can kindly appreciate that if the allegations of cheating by personation is there. Now the cheating has to be from the inception. Now it has to be from the inception. Now, if Your Lordships can see, the moment I enter into an agreement with the respondent number 2 to supply an SC organic bag, the money I have received from them, the next day I have placed the order before the company. That is on record, Your Lordship.
You see, whether the intention to cheat was there or not at the very beginning, that also becomes a matter of evidence. You are correct in contending that to prove an allegation of cheating, there must be a case where it is shown that you had the intention of cheating right from the beginning of the deal. Now, with what motive you have executed this agreement and whether you had any mala fide intention at the stage or not, that will be decided at the stage of trial, which will be concerning the merits entirely. Now, so far, the purpose of this case is concerned. The very allegation that you impersonated yourself and entered into an agreement, that is good enough to show that you had guilty intention from the very beginning. Because you projected yourself to be somebody and induced that person to enter into an agreement.
That's the allegation.
See, more you argue on facts, more it will bring trouble for you in the later parts of the trial. If you are not successful here, then you will have this finding arrived at. More you try to argue on merits, and any finding, if you raise certain question, then court is bound to give answer or bound to answer. So you see, like if any finding comes, this may have adverse effect in your trial. Think over Do not know, but then as it appears now, I don't think you have a case, good case.
Lordships,
You want more
I have,
preparation?
I don't think, Your Lordships, I have to argue on the merit to satisfy that. But since
So
that,
like then if you do it, then it's no problem. You do it. You can argue on merits, but then that is a well settled law. There is no dispute with regard to that. No problem. You can just say we'll note the things.
Your Lordships, then it might come next to Your Lordships.
That you can do it, but then do you think this kind of things? Think about Mr. Roy.
Your Lordship.
Law is very much clear. I don't think there should be any doubt in your mind. Even see the recent decisions of the Apex Court.
Your Lordship.
To what extent in 482 the quashing cases? To what extent court?
So it has to be this brand.
This is settled even 2023 or 24 also.
Yes,
This is when I think Amar judgment. He says that court cannot conduct a mini trial. Cannot say that the FIR doesn't make out a case. You may have a very good case on facts, but then we cannot entertain it at this stage, saying that there is no basis of lodging this FIR. Okay, that is the problem.
Your Lordship, then
You have to neither do this court have the power to go into the documents produced by you. We cannot give a finding with regard to the merits of the allegation by looking at your documents. The prima facie, we have to accept it is correct, and whatever document is there in support of the allegation. That is what is to be said. That is what the law is. Just you can verify it and prepare it that way.
Your Lordship. 1 week time may be granted, Your Lordship. I'll seek instruction in the meantime.
We just see. We can come. That is what this is the mind of the court.
Your Lordship.
Yes. We'll have it after a
He'll
week.
come next week after a week. Let him get the
Your problem is solved for the day. Okay. Just Mr. S.K. Roy, Learned Counsel, let me the petitioner. Please for grant us some more time to enable him to prepare the matter. The state respondents, the counsel appearing for the respondents have no objection. List after a week.
Your
That
Lordship.
will be sufficient for you.
Your Lordship.
Think about it, you have a tough case.
Your Lordship. Highly obliged.
Nothing new.